and take it as my first argument. I apologize, Scott Peter, on behalf of Zach Burstein, Stephen Cook, and Harris Bookbinder, the attorney that the respondent has successfully disqualified at the trial level.
Counsel, would you like to reserve a couple minutes for rebuttal?
Yes, Your Honor, 3 minutes, please. As this court well knows, the issue is were the essential requirements of law met at the trial level, and this court recently ruled last month, I know Judge Shepard was on the panel in the Morber case dealing with the law firm of Waldman and, I can't pronounce it, Alluring, where all of these principles were enunciated again. And it's simple. There is a due process requirement that if the facts are at issue, there must be an evidentiary hearing. That did not happen in this case. There was a proffer made at the trial level. The court, for whatever reason, did not permit evidence to be provided, ruled, and then said, put the deposition testimony in the record. But the court had already ruled, so the due process requirement was never met. That in and of itself is grounds for reversal because disqualification is an extraordinary remedy that should be sparingly granted. These litigants are entitled to the lawyer of their choice.
And if that were to happen and this were to be remanded, what would the evidentiary issue be?
Exactly. And the substantial competent evidence does not exist to warrant.
What would the evidence be to disprove the propriety of disqualification here? First, how would you prove what seems to me to be essentially a legal issue, whether certain issues are intertwined in the earlier representation?
First, there was no earlier representation that was substantially similar to this case. There were 2 representations some 14 years earlier. One dealt with a parking lot in Broward County and conceded by my adversary has nothing to do with this case. The second had to do with a promissory note, nothing to do with this case, completely unrelated.
Well,
and then the third,
don't all of these cases have to do with a bank that was owned by an entity? You know, these individuals, Burstein, Cook, and Marlin, were managers of an entity that owned a bank. You know, owned one corporation, held all the stock, or they owned another corporation that owned a bank, and their promissory notes were related to those entities, and then the bank got taken over, and then the parties split up to decide how to recover from that failed bank, and they went separate ways. Cook and Burstein went one way, and Marlin went another way, and they had, you know, they were all fighting about the money and about the bank, about recovering, and who was at fault in recovering, and Mr. Buckbinder represented Mr. Marlin, did he not? In some of those fights about the promissory notes, Mr. Marlin formed an entity, bought the promissory note, wanted to collect on the promissory note. Yeah? No, Mr. Buckbinder didn't have anything to do with FBK and Marlin and those lawsuits.
If I might, first, no. My answer no is the facts that you're talking about, not Mr. Buckbinder's representation. The parking lot case and the promissory note case has nothing remotely related to any issues in this case. The ownership of the bank by Mr. Burstein, who was a director, Mr. Cook, who was a director, Mr. Robert Marlin, who was a director, had nothing to do with those issues. That promissory note had nothing to do with it. That's what I'm talking about. For example, one of the cases was simply to force someone to sign a corrective deed.
We're talking about after ACC failed.
Right.
Let's get down to that.
Right.
Burstein and Cook went one way to try to collect some money on a good faith claim, and Mr. Marlin formed a corporation, supposedly also to benefit ACC. Did he not?
No.
FBK?
No. Mr. Marlin did not form FBK. Mr. Marlin said in affidavit that he did. The 5 partners of FBK all said he did not. In his deposition, Mr. Marlin...
He wasn't the general partner.
He was not, and in his deposition, in this case, the evidence that would have been needed to be looked at by the trial court, Mr. Marlin admitted that he was never a partner of FBK. He contradicted his affidavit.
Who represented FBK in the lawsuit on the promissory note?
Mr. Buckbinder represented FBK on behalf of Kenneth Marlin. not Robert Marlin. Robert Marlin was not FTK. That is exactly the evidentiary issue.
Despite the fact that he said in an affidavit that he was.
He said in his affidavit, the affidavit signed, that he was. In his deposition, in this case, he admitted, no, I wasn't. He had to, because he never was. He never was FTK. In fact, and this is out, well, I'm not going to go outside the record. That's why we need evidence, and we never got a chance to continue to provide the evidence to this trial judge regarding.
And how did your clients preserve that? In other words, following the initial hearing, did they complain that they wanted a further hearing?
Yes. Throughout that hearing, in the record of that transcript, Mr. Buckbinder is attempting to have the judge perform the evidentiary hearing. Mr. Buckbinder said in the record that this is not, we can't do it by proper. He even challenged the fact being proper and said, Judge, you need to see the evidence. We need to do the proper hearing. The judge, for whatever reason, did not want to go through with the process. Again, coming back to, and that's key that Your Honor has pointed out, Judge Wells, FBK, in the affidavit, Marlin says, I was FTK, but in his sworn testimony.
Let's get over Mr. Marlin. Let's get over Mr. Buckbinder, represented FTK, and he sued, who did he sue? He sued ACC, Burstein, and Cook. Did he not?
On behalf of FTK, which has nothing to do with Robert Marlin.
But he sued the people now, right? He sued these people. And now we get to the lawsuit. And who does he want to represent currently?
They want to represent him currently. The litigant has every right to choose the lawyer of their choice. As a lawyer, I can go to the lawyer who sued me on this ministerial, by the way, the FTK case was a ministerial claim. But Jack Burstein and Steve Cook want Harris Buckbinder to be their lawyer. There is no ethical rule that prohibits that. None at all. Robert Marlin is the complaining party today in 2011 when he raised this issue, and he's complaining about the FTK lawsuit back in the 1990s, on top of which FTK was owned, and by the way, excuse me, FTK did not sue American Capital. The trustee of the bank sued, not the trustee of FTK, the trustee of the bank that was holding on behalf of all the beneficiaries. FTK was just one of the beneficiaries. And as a matter of law, the court is aware, in the Barnett Bank case, the First Union case, they're cited in the petition.
The trustee basically was the holder of the notes and authorized FTK to sue, correct?
No, the trustee sued. Didn't authorize FTK to sue. The trustee sued. The trustee sued on the note on behalf of hundreds of beneficiaries all over the country. Literally, FTK was one of those beneficiaries. In fact, FTK bought its interest long after the fact, which they're entitled to do, but they bought their interest from other beneficiaries. So you have this stretch, and it's a promissory note case, and there are no issues in that case remotely related to the issues in this case, and that brings us to the final point. In his affidavit, Mr. Robert Marlin says, I gave confidential information. In his deposition, he says, and I'm quoting him, there was no secret information. Mr. Buckbinder asked him, what did you allegedly tell me? I can't remember anything. That's at page 8 of the reply brief. He can't remember a single confidence. He admits there was no secret information. So we have none of the standards met. No evidentiary hearing, no substantially similar representation, and no confidential information. And to disqualify a lawyer, as this court recently said, there must be substantial competent evidence. Due process wasn't met.
May it please the Court, Mark Gottlieb on behalf of the Respondent. I'd like to take up each of the 4 main points addressed in the cert petition, bearing in mind the high hurdle that the petitioners need to clear in this particular case, which is that the lower court had to have departed from the essential requirements of law, which is an extremely high hurdle. The first point they raised relates to Mr. Buckbinder's claim that he only represented the trust, and the trustee was an indentured trust that held these notes, and didn't represent the beneficiaries of that trust. And he cites and relies on a case law, the Burstein case, which is easily distinguishable. In that case, the beneficiaries weren't suing the trustee. The beneficiaries sought to get access to privileged communications between the trustee, counsel, and the trustee. And in that situation, where the beneficiaries were directly adverse to the trustee, the court said, no, the privilege there belongs to the trustee, and you don't get access to that as a beneficiary. You are not the client. However, the second DCA has held that where a trustee brings action on behalf of the beneficiaries and their interests are aligned, that the beneficiary may well be considered the client to whom duties are owed by the attorney. That's exactly the situation we have in this case. Mr. Bookbinder conceded it. He conceded, as he had to in his deposition, that the impetus behind this whole lawsuit was FDK. FDK went to SunTrust and said, we want to bring action on this note. We are directing you to bring action on this note. We want you to hire Mr. Bookbinder. We will pay his fees. We will direct that litigation. Mr. Bookbinder conceded that the suit he brought was for the benefit of FDK. FDK was his main contact. FDK directed and paid for that litigation. So under that circumstance, contrary to the arguments that they've made, the duty is owed by the attorney to the beneficiary, which is FDK, which happens to be not one of hundreds of note holders, but the largest note holder who was calling the shot and who directed this very litigation. The next argument that they try to make, that they can't get past this issue about the trustee, is they say, okay, well, let's assume FDK was a client. Mr. Marlin has nothing to do with FDK. And they rely on some deposition testimony, actually was taken in another case, in which Mr. Marlin said, I never acquired my ownership interest in FDK. And that was a legal conclusion drawn by prior counsel because he said the partnership interests were never formally issued. He went on to explain in his deposition that I always acted as the managing general partner of FDK. I was one of the people who directed its operations and was integrally involved in the affairs of FDK.
Well, did I understand counsel to say you got the wrong Marlin?
He spoke about the wrong Marlin.
Two Marlins.
There were two Marlins. They were brothers, and at the time their interests were aligned. And there was substantial competent evidence presented to the lower court, including Mr. Marlin's affidavit, but also including deposition testimony and documents that were presented to the court at the hearing that showed that Mr. Marlin was affiliated with FDK. There was a partnership agreement.
The testimony that you just cited was Robert Marlin, not Kenneth Marlin.
Robert Marlin.
Was there any request, or did they preserve the evidentiary hearing point?
I don't believe they did preserve the evidentiary hearing.
Because the way that's set up was with the affidavits and some deposition excerpts. And then, as the hearing was noticed, was it noticed as an evidentiary hearing?
It was not noticed as an evidentiary hearing. It was noticed as a specially set hearing. It was noticed 3 months prior to the actual hearing.
Right. And then as the hearing began, were the objections put on the record immediately, or was that a little down the road?
No objections were put on immediately. As the hearing began, the posture that we were in, we had filed a motion supported by detailed affidavits and documents.
And nothing had been filed in?
No opposing affidavit, no opposing memo. We get to the hearing, we present our side of the case, we argue based on the affidavits that have been filed, and then afterwards, Mr. Bookbinder starts proffering his own testimony and arguing that there needs to be an evidentiary hearing. But the cases, and we've cited them, the Sears case, and I believe the Allstate case, out of the ones out of the 4th DCA, I think ones out of the 5th DCA, make it clear that an evidentiary hearing is not required in every instance where you have a motion to disqualify. It's required where a well-supported motion, supported by affidavits and evidence, has been controverted by opposing affidavits, and there's an actual conflict in material facts that underline the motion to disqualify. You didn't have that here.
And at the hearing, Mr. Bookbinder did not bring counsel to represent him to put on his testimony.
Did not, no.
And the retention of his testimony, the retention of counsel was for purposes of this appeal, it looks like.
Correct. I believe that Mr. Peter did appear at one subsequent hearing in the case in which Mr. Bookbinder, despite the disqualification, continued to file motions and attempt to advance arguments. But getting back to the issue of FDK and Mr. Marlin's involvement in the company, you had evidence presented to the court. Beyond Mr. Marlin's affidavit, there were documents that Mr. Bookbinder was questioned about in his deposition, including a partnership agreement that identified Mr. Marlin as the managing general partner, including an agreement executed by Mr. Burstein when he was the president of ACC with FDK on the other side, which Mr. Marlin executed as one of the three managing general partners of FDK. In addition to which, the entire argument is disingenuous. Mr. Bookbinder wanted to stand up and say, Mr. Marlin has nothing to do with FDK, and yet the evidence, and again, we submitted the deposition testimony to the court. We didn't file it because there was a protective order that precluded its filing. But the evidence that came out of that deposition was that Mr. Bookbinder was regularly communicating with Mr. Marlin, Mr. Robert Marlin, about this noteholder lawsuit. He wants to say that Mr. Marlin had nothing to do with the case, and yet his own correspondence shows that he was copying Mr. Marlin on all the correspondence in the case. The very position that he took in this litigation is contradictory to his contention that Robert Marlin had nothing to do with FDK. In this very case, the affirmative defense that he raised was that Robert Marlin formed FDK. He put together the investors. He was the driving force behind it. He was the one who instigated FDK to bring the very suit in which Mr. Bookbinder represented the interests of the noteholders and ultimately prevailed. As far as the substantial relationship in that noteholder lawsuit, ACC, led by Mr. Burstein, who's a party to this case, raised as an issue an allegation that the noteholders should be stopped from being able to prosecute that action because Mr. Marlin, Mr. Robert Marlin, was behind the suit and because Mr. Robert Marlin had breached his fiduciary duties to ACC. Mr. Bookbinder defended against that very defense and defeated it. He shows up in this case arguing the very same defense that he was on the opposite side of when he was consulting with Mr. Marlin, albeit a long time ago, consulting with Mr. Marlin on these very same issues. So in terms of the substantial relationship, we don't have to talk about the sort of general relationship of ACC and the noteholder litigation and of the affairs of Mr. Marlin and Mr. Burstein in connection with those entities. We need to look no further than the affirmative defense, which Mr. Bookbinder himself conceded was the very same affirmative defense that he appeared on the other side of 10 years ago while representing the interests of FDK and Mr. Marlin. One other issue that they raised, and I'll try and address it quickly because I know my time is running short. They say that Mr. Marlin, in his testimony, couldn't identify the quote-unquote secret information that he had disclosed. That was in response to a specific question from Mr. Bookbinder. What secret information did I divulge to you? But what Mr. Marlin did say is, I can tell you in general what we discussed. We discussed this breach of fiduciary duty issue and whether it had merit. We discussed Mr. Burstein and Mr. Cook and whether they had engaged in acts of malfeasance vis-a-vis ACC, facts that are relevant in this litigation. We discussed potential claims I believe, Mr. Marlin believes he had against those parties. He's not required to give chapter and verse and a detailed explanation of every privileged communication that he had with Mr. Bookbinder. He gave the general subject matter. That general subject matter is clearly related to and relevant to the litigation that we're in here today on. And the comments to Rule 4-1.9 make it clear that the court can draw conclusions and make inferences based on the nature of the representation and the fact that a lawyer would typically learn in the context of such a case as to whether privileged communications were in fact divulged. You don't need to force the client to give chapter and verse of everything that I told my former counsel. Especially the lower court was eminently correct. It certainly cannot be said that they departed from essential requirements of law in this case, and we would ask that the petition be denied.
Thank you. Counsel?
Your Honor, if I may, there was one hearing, not multiple hearings. The one hearing was the special Fed hearing. The evidence was controverted. I was there. And I was there should Mr. Bookbinder's testimony occur. And at the beginning of the trial, or the hearing that was discussed, they did not file anything in advance of the hearing except the affidavit. We went to the hearing to go over the evidence Mr. Bookbinder had controverted by his opposing their motion to disqualify, first of all. Second of all, what happened at the hearing just happened here. Counsel says he was a partner. We had a partnership agreement. The document was not ever signed. And the partners all said Robert Marlin was not a partner, but even better. I just want to read, quote unquote.
But the claim, when you get down to the bottom of Mr. Bookbinder, on behalf of the SunTrust and ACC on the note, there was a counterclaim. There was a claim. There was an allegation that Mr. Robert Marlin, I believe, had breached a fiduciary duty.
There was an affirmative defense, Your Honor.
And so that was all involved in that lawsuit. And here comes the...
No. The affirmative defense was filed, and within weeks, as a matter of law, without any conversation ever occurring between Mr. Robert Marlin and Mr. Bookbinder, Mr. Bookbinder had it stricken. The affirmative defenses were stricken. And that was Mr. Bookbinder's evidence. There were no conversations. Counsel now said that in the deposition in this case, Mr. Robert Marlin, first of all, he swore an oath. This is Robert Marlin. This is at page 7 of the reply. And from its inception means from the very beginning of SDK, you never owned an interest, correct? Answer. That's what it says. Secondly, he says that he did disclose discussion. There's not a single answer under oath by Robert Marlin that he had any discussions about any issues. He was asked, and this is at page 15 of the reply, tell me exactly what you told me back when supposedly you hired me to represent SunTrust. Tell me all the things, all the conversations we had. Tell me what they consisted of. Answer. I can't at this time. This happened a long time ago, many years. Can you tell me anything? No. That's the point. We deserve, Mr. Bookbinder, more important, Mr. Burstein and Mr. Cook deserve to have the evidentiary hearing because the proffer you heard today is the same proffer then, and there's no substance to it. The affidavit, which looks very good on its face, was contradicted by Mr. Robert Marlin in his sworn testimony because the affidavit was not in good faith. So, again, this court has said it should be sparingly granted disqualification. There must be substantial competent evidence. The lawsuit by SunTrust...
Counsel, I'd like to go over your time. So, in conclusion, you would like for us to...
simply reverse and remand to the trial court to hold the evidentiary hearing so that all of this could be developed properly.
Thank you. Thank you both.